We know that none of these people have resigned from their political parties. We also know they have not been expelled. But some people argue that the moment you try to contest as an independent.
Is it people arguing, or is it the NPP constitution speaking?
No, the NPP constitution says words to that effect. But as a lawyer,
no words to that effect. It says exactly so.
Okay,
yes.
Let be as me. But for me, I don't only read the constitution the way it is written. I also act what we call constitutional conventions. The convention of the NPP had always been that if you make such a conduct, first of all, they will try to engage with you. Having engaged with you, if that fails, then they write to you to tell you that you have been expelled.
Can you give me one example? One example.
Where they have done
that?
No,
hold on. One example.
Okay.
Of an NPP MP.
Yes.
Who filed to contest as an independent candidate.
Yes.
Who, at the time of the EC issuing the statement of poll,
okay,
was an independent candidate on that statement of poll, together with an MPP candidate who was engaged.
I don't have that. I don't have that in mind, but I know other instances.
So where are you taking
I know other instances whereby a misconduct has happened, and the person was written to. I also know that the Formula MP,
because what you are speaking,
let me. I'll satisfy you.
Yeah, okay.
I also know the Formula MP. They had engaged him, he couldn't succeed, and they wrote to the former Speaker of Parliament that he has been expelled.
No, you're not getting me.
Okay.
I'm saying that.
Yes.
When?
Yes.
Since when? When is you talk about constitutional conventions?
Okay.
So I ask.
Yes.
Since when has anybody?
Yes.
You know, when you talk about misconduct, the MPP constitution is clear.
But I mentioned the Formula MP.
No, I'm saying that the Formula MP was not engaged after the statement of polls had come from the EC.
No, I don't know that. They do it behind the scene. Engagement, you wouldn't know. They do it behind the scene. Oh. And I think that engagement failed. That was why they've written to the Speaker to say that he has been expelled. But that's one issue. Look, I'm trying to take politics out of this and try to analyze it using my legal.
That is what I'm trying to.
The third one,
Chief,
you might.
That is what I'm. No, that is why I'm trying to draw your mind to, because what you're doing would also create the impression that although it is in black and white that the party can expel you, that you can resign. It is also in black and white that if you engage in a particular conduct, automatically it's forfeited.
That's where I'm coming to my third
Chief, I'm coming. However, in all of those three instances, even when people have put in resignation letters, they are still engaged. Even when there are letters to expel people, there's still engagement.
I will come to what you're explaining. That is my third point.
Okay.
So if we don't have clear reason that you have been expelled, and we don't have the fact that you have resigned, there are instances whereby your conduct element might be able to demonstrate that you are no longer with a political party. I accept that. And I think that's the basis in which the Speaker was trying to make the decision, or probably made the decision. So the conduct element, again, we go to legal theory. It can help us in terms of attempts. There are two theories here that is engaged. One would be if your conduct is more than merely preparatory. Other people has argued that it has to be the last act. Majority say the last act is very absurd. But your conduct has to be more than merely preparatory. So one way would be the fact that you have filed to contest as independent and the notice of poll. So some people, on the basis of that particular decision, I think whether they remain MPP members or they have left, it can go either way, but because, as I said, the theory is either more than merely preparatory or the last act. So I believe on that particular specific question, the Supreme Court would decide either way. Now, the second question would be, who has the right to make that decision? And if you listen to our Marking argument, this is some of the argument I've been making all along. Because for me, Article 99 is very clear that the person who has a right, the body that has a right to make that decision is the High Court and not the Speaker of Parliament. And that was why I said that the previous Speaker of Parliament, Professor Oquaye, was wrong. And you can't say because he was wrong, we have to be consistently wrong to be right. That would be a definition of madness. Why am I saying the High Court? The Article 99 is very clear. Determination of membership of Parliament. to determine whether somebody has been validly elected as a member of parliament or cease to be a member of parliament, that question needs to be answered by the High Court. But other people said Parliament has that power, because if you look at Article 110, at least I've listened to some of their lawyers who argue Article 110. That says that Parliament would have the right, it says that subject to, let me just get the provision right. Let's have a look at it together. It says subject to the provision of this Constitution. Already this is a clawback clause. When it says subject to the provision of this Constitution, it tells me that the Constitution have already given powers to others. That is why it says subject to the provision of this Constitution. It's a clawback clause. Now, it's a Parliament may by standing orders regulate its own procedure. So some people have argued this is where Speaker draws his powers from. But this is not specific. It's a procedure. Then you go to the standing order. I've seen the standing orders. I don't know whether it's the latest standing order. But I can say Article 19. Yeah. Article 19 of the standing order, that made it clear that the Speaker of Parliament would have the power to declare vacancy in Parliament. Am I right?
To inform.
Okay.
Using the word inform.
Okay. So that article, that's where people are going. And I think that is a problem area. Right. Again, as a lawyer, you have to go back to legal theory. Now, specific powers have been given to somebody. And then a general power is given to somebody. So people would think there's a conflict. But there's no conflict. I believe you are familiar with Professor Hart's theory of law. So Professor Hart's theory of law and Dawkins' theory of law could help us. And I believe the Supreme Court is likely to deploy some of these theories. So Hart says that when you see this thing, there are differences between these two, then lawyers will be called upon to
differences between which two?
You see, I say Article 99 has given specific powers.
Which part of, guys, help me. Which part of the Constitution speaks about deliberations, proceedings, and speeches made in Parliament which cannot be questioned anywhere? There's a part of the Constitution. Yes. I hope you are aware of that.
I am aware of it. Okay. Provided you are staying within your power.
No, just what I'm saying, that there is a constitutional provision.
Yes.
That deals with that. Proceedings, deliberations, and...
But if you look at the history of it, it didn't say Parliament has got unlimited power. We borrowed it from the
Westminster. That's not what I'm saying.
I'll try to explain to you the history of it.
Okay.
I've done the UK constitutional law.
Okay.
We borrowed it directly from over there. What was the essence of it? It was actually meant to protect parliamentarians because they have a history of killing even speakers of Parliament. It was meant to say that speech in Parliament cannot be questioned. It's more or less like to protect you from defamation and criminal liability, but not when you exceed your power.
It goes beyond speech.
Well, that's my understanding of it. But let me come. But that's not what their lawyers is arguing. The lawyers is arguing around 110, Article 110. But my argument here is that people think these two conflict, but they don't conflict because we can go to we can go to legal theory to see that if a specific power is given to somebody, if I'm wrong, he'll correct me. And then a general power is given to somebody. Assuming the standing order is the one that gives the speaker the power, which is drawn from 110. We have a principle called specialibus generalis derogat. So we call it short lex specialis rules. If a specific power is given to somebody else, and a general power is given to somebody, the specific power takes precedence. So I believe it is the High Court. If you apply this constitutional principle, a specific power is given to the High Court, a general power is given to, if you want to say, Parliament, the specific power will prevail. This is why I believe that Professor McQuay was wrong. This speaker is wrong under this particular circumstance. And now let's come to the specific provision. What does it say? If he seeks to remain in Parliament as an independent. Now, you are already familiar with the argument. The argument is that this particular provision doesn't cover people who wants to come back in the next Parliament as members of either independent members or members of a different political parties. Others said it immediately affects anybody who has expressed the intention now, even though the life of the parliament hasn't ended. I believe there's a problem over there.
Why?
They give rise to interpretation.
Why is there a problem?
The problem is that if he seeks to remain as an independent member, but these people are not seeking to remain as independent members now. They are seeking to come back in the next parliament as independent.
So let me ask you a question.
Let me devolve this before you come.
Yeah, please do.
If you look at Special Tribunal ex parte Akosa, the Supreme Court gave 4 instances whereby a provision of the Constitution must be referred for interpretation. And one of them is that if there's a rival meaning placed in any provision of the Constitution, it is the Supreme Court that has the power to make an interpretation. So having said that, now they have ceased with the matter. I believe their jurisdiction was properly invoked.
So let me ask you a question. Okay. Now that you have explained your legal whatever.
Yes.
Assuming that that provision was to speak about future, the next parliament.
Yes.
What would be the essence?
There will still be essence.
What would be?
No,
just tell me what the essence will be.
No, it's not this provision is talking about future.
No, I'm saying
their conduct.
I'm saying that.
Yes.
If it is not about conduct in this particular parliament,
yes,
but it's about conduct in the next parliament,
there are some.
What will be the essence?
There are some people whose conduct in this parliament would be engaged.
No, let's use this specific example.
No, but why do you have reality when you are using hypothetical?
The reality is that today.
No, the reality is that when you look at why Seni case, for example, he was seeking to cross immediately.
Let's have this. So today, please read the part that speaks about an independent candidate. Can you read that part for me?
So if you go to 97, I think G, if he leaves the party of which he was a member at the time of his election to parliament to join another party or seeks to remain in parliament as an independent member.
Okay, so if he leaves the party of which he was a member at the time of his election to join another party or seeks to remain in parliament as an independent member, does this not tell us that it is for the life of the parliament that the person was voted into?
It hasn't. Let me explain.
And if you move on, if you move on, and you go to the H, what does the H tell us?
Outcome. Let's resolve the G before we go to the H. I understand you as a lawyer. It might look so plain to you, but I believe my friend will put political differences aside. I believe that the court will go back to legal theory. You see, Professor Ishaq has written an article, and the title was "No Vehicle in the Park," as part of demonstrating how judges are supposed to resolve the cases. So no vehicle in the park, just as similar as if he seeks to remain in parliament as an independent member. Clearly, this doesn't look like there's a problem in it. But in legal theory, he said we have a core meaning of words use, and we have what we call a penumbral meaning. So the core meaning will be understood like you linguists, that if you see the core meaning like this, usually it will be now for some people.
Because parliament has a life.
Let me come. Let me devolve
Parliament has a life.
Yes.
It says that when you are elected and you seek to remain. Is it not speaking about that life?
As I said, I appreciate where you are coming from.
And especially when it goes, hold on. Especially when it goes, it goes to even the H.
Yes.
You will see that prior to the G and the H, it speaks about people elected on party tickets and people who are elected as independents. Then now it comes to give you a breakdown. It separates the party and the independent. But it's all speaking about the life of a parliament. How is this penumbra and...
No, because you don't want me to finish.
Oh, please do.
Allow me to finish.
Please do. Me, I learn every day. Please do.
I don't fault you for the understanding that you have. Because I expect you to have that understanding. If you are not trained in that area.
Help me to understand the penumbra.
So you are understanding the core meaning of it. Now, there's a dispute as to the core meaning. And this is a reason why...
Dispute between who and who?
Of course, I am here. I'm disputing it with you now.
No, I want to... I am asking you, all I've done this morning is to ask you to convince me.
Yes.
Why there has to be a different meaning to this?
I'm trying to explain it to you. So the penumbral the core meaning that you understood, and I accept you are right to understand it that way. People believe that there is absurdity in it. So core meaning, so if there's absurdity in it, this is the reason why we want a court to decide. Professor Harris said if the core meaning is given...
What's the absurdity? What is it?
What's the absurdity is that we believe that these people are seeking to come in the next parliament. And other people said, so we saw the people who said it should apply now to be absurd, because the people are not seeking to remain here. They are seeking to come back in the next parliament. And the word even used that if they seek to remain. In the current parliament, they are seeking to remain as an NPP member. They will continue to vote and have loyalty to the NPP in this current parliament. What they are saying is the next parliament. So if a court is seized with this thing, Professor Hart advice is that we have to go to, the court will look at the core meaning and the penumbral meaning.
So what I'm asking you is that...
Let me develop it beyond the penumbral meaning, then you come.
Okay.
So the penumbral meaning would then tell us the court need to interpret it and then come out with the results. The result that we get after the interpretation is give out what we call the penumbral meaning. And one of them would be, what was the reason?
Yes.
What was the reason why this clause was put here in the first place?
Yes.
Other people then call it purposive approach.
Yes.
So the court would ask, what was the reason?
Yes.
And
did you read Professor Oquaye's purposive interpretation in his ruling on this matter? Did you read that?
I've told you from the beginning that I disagree with him.
Not you disagree.
Yes.
With,
I think it was wrong.
Hold on. You disagree. What you have told me, unless I'm wrong.
Yes.
What you have said here is that you disagree with the exercise of the power to declare the vacancy.
Yes.
You think that it is vested in the High Court.
Yes. Yes.
But you have never told me that you disagree with his purposive.
I've not seen his purposive approach.
That's why I asked you. Have you read it?
No, I haven't read it. If it is not his decision in the first place, whatever interpretation he placed will be wrong, because that's not his decision. It is a High Court decision. That is not his decision. So as I said, if you
but you cannot be wrong. It's not your decision to decide this matter. But, you are here
but as a citizen,
expressing an opinion.
Yes, but that's why I'm saying, I'm saying he's wrong because I'm expressing an opinion.
Yes.
What I'm saying is not a fact. Okay. It's the Supreme Court that will decide.
Yes, so yes. So if I want to still understand that how will there be any other?
Yes, so any other would be to go to memory lane. History would tell us what was the reason why this provision was there.
Yes, and what
from my reading, the 1969, what they call it, Constitution had that provision. I think that was the first time it appears. And what they have realized is that Nkrumah government at that time was attempting or succeeded in weakening the opposition. People will elect their parliamentarians, come to parliament. He realized that he doesn't have the required number of people, parliamentarians, to be able to vote for his legislation or whatever he wanted to do in parliament. So what he does is that he caused some members to cross carpet to his party, give him the required number. So the whole idea was to have a strong government and a strong opposition. And they would remain the way they were when they were first voted for. And if you were seeking to weaken other side, then the electorate will be called upon to make a decision again. So if you see it, that was a mischief they were trying to prevent.
Including the H.
Which one?
The H.
I'm still explaining the F. The G. I'll come to that. Now, 1979 again, that clause was there. And now 1992, that clause came in. So I believe looking at the purposive approach, what they are doing will not weaken the government or opposition at this time. It's not going to. It's the next parliament that their decision would have effect.
How? So in the next parliament, how will it weaken or strengthen any party?
No, I said it will have effect, even if they win at all. But this current parliament, I'm saying that this current parliament, as it's constituted, their decision is not going to have any effect in it.
Okay.
Yes. So
move on to the
yes. So the G is if he was elected as a member, the H. If he was elected a member of parliament as an independent candidate and joins a political party.
So that one too is futuristic.
No. This one, I've not delved so much in it, but my understanding of this would be to determine whether the former MP have actually joined the MPP. And it will be a question for the court
to
also
determine. Is he not the MPP's candidate in the election?
He is a candidate, but I'm not sure whether he once left the party. When did he join? Do you know when he joins?
I know that he is the MPP's candidate for Fomena. That's what I know.
But do you know when he joins?
I don't know.
We don't know.
But as we speak today, he is the MPP's parliamentary candidate.
So again, the purposive approach will work here. The purposive approach would be that his decision going to affect the current parliament. Look, we are not in hurry. This is 9 o'clock. Probably the Supreme Court will make pronouncements on this.
Okay.
And they may give me a better reasoning than what I'm trying to give you.
All right.
But my knowledge of legal theory tells me Professor Oquaye was wrong. Our current speaker is wrong. And we cannot be right by being consistently wrong.